Hello everyone, and welcome to this special weekday Motor Trade Radio podcast, powered by eBay Motors Group, with Philip Nothard and Curtis Hutchinson, bringing you all the chatter that matters across the franchised and independent dealer sectors.
This week, we're delighted to welcome our special guest, Lewis Adamson, Senior Associate with Geldard, the highly respected national law firm and motor retail legal specialist. Lewis is joining us to discuss a particularly hot topic for dealers, Discretionary Commission Arrangements, or DCAs, paid on consumer motor finance. So welcome to the pod, Lewis.
Thank you. Great to be here. Thanks for having me.
Yeah, welcome. So I know it's a busy time in general for Geldards and everything going on, but I'm sure we'll get into some of the detail of this. But this has probably kept you busy most recently. This is
Extremely busy.
Yeah, I can well imagine. But yeah, welcome and thanks for agreeing to do this. And I know that as Curtis has said there, it's very much a hot topic. I mean, there's we talk about on the headlines most weeks now. There's something hitting the news about it. So thank you for coming on to share some information.
No problem at all.
So as I say there, you've been working very closely with dealers, and it's probably more than recent months, but it's very much hit the headlines over recent months on the subject of DCA. Can you start with some of an outline of what DCA is and what prompted the FCA's investigation into the current position of the DCA?
Yeah, of course. So a DCA, Discretionary Commission Arrangement, it's essentially a commission model whereby the lender gives the broker, in this case a dealer, the option to offer credit terms to its customers within a certain range of interest rates. So for example, the lender says to dealer, you can offer interest rates between 5 and 15%. And the higher the interest rate, the finance product ultimately entered into, then the higher the commission will be paid to the dealer by the lender. So that, in effect, is a discretionary commission arrangement. And the FCA investigation is the result of something that's been brewing over the last few years, really. They initially conducted a review of commission arrangements in October 2019. And without going into too much detail, because we could talk about this forever, ultimately this led to the FCA deciding to ban DCAs from January 2021 onwards. The Consumer Credit Sourcebook rules, or the CONC rules for short, were revised accordingly. And the reason behind this was the FCA rightly said, if discretionary commission arrangements were to remain, then there was an incentive there, in theory, for credit brokers to offer higher interest to increase the commission they will receive. So by banning the DCAs, that incentive was removed. That's not to say, though, that certainly in the case of dealers, just because they'll be paid a higher commission would mean that they'd automatically go for the higher interest rate. It's all a matter of competition and perspective, the deal in the round, so to speak. But we'll get into that later. But the banning of the DCAs from January 21 also happened to coincide and be followed with a Court of Appeal decision in March 2021 with the cases of Wood and Pengelly and Commercial First Limited. Now, these were claims against mortgage brokers rather than dealerships and car retailers. And it was found that, or the law was developed and set by the Court of Appeal, and they found that where there has been a fully secret commission paid, the civil remedies that are available in the circumstances, even without the existence of a fiduciary relationship, and those remedies, as well as the right of rescinding the agreement, also included the right to receive as compensation an amount equal to the commission paid by the lender. So the consequences of this decision and the banning of the DCAs by the FCA seemed to lead to a number of claims management companies and some law firms who are looking for the next big thing, really, as PPI claims start to dwindle and phase out. So these claims management companies start looking into the DCAs further. And this really led to a vast number of complaints and county court claims being brought against lenders and retailers alike on the basis that customers were not told that dealerships would be paid a commission, and certainly not that the interest rate would be linked to the commission. And they therefore sought compensation as a result. The compensation being the amount of commission paid plus interest and other damages. The majority of these claims and complaints have been rejected and defended by lenders and retailers involved. And the Financial Ombudsman Service, FOS for short, have also been inundated with numerous complaints on these cases. The FOS themselves have, and which sort of sparked all of this, on 2 occasions reached decisions which were unfavourable to the lender. But there's also been mixed success in the county courts. Some cases were successful, others not. I've been involved in some on behalf of retailers where we have been successful in defending them. I'll come on to this a bit later and Geldard's experience of such claim, but all of this together, mainly due to the large scale and the amount of complaints and claims being made to lenders and retailers, coupled with the lack of clarity as to what the legal position is and what the response by these firms should be and whether there is actually a genuine claim here, has prompted the FCA to step in. And the FCA have decided from January this year to conduct a review using their powers under Section 166 of the Financial Service and Markets Act, which entails the FCA instructing an independent third-party investigator to review historical motor finance commission arrangements and sales across several firms, with the ultimate aim of deciding whether, in the FCA's opinion, there has been widespread misconduct in the use of DCAs. And we should be hearing something from them in September. Whether that remains to be the case, it remains to be seen. The background, really, of where it all comes from.
Yeah, no, thanks for that, Lewis. There's some great context there. And you've teed it up beautifully because the FCA arrived pretty much on the scene in January. And of course, since then, we've had the campaign that's been launched by Martin Lewis and Money Saving Expert. And it's been a high profile TV campaign. What sort of impact has that had on DCA claims? Well,
I'd say the impact hasn't really affected the general position in respect of these claims in the dispute. These types of claims were already being widely advertised prior to Martin Lewis's involvement by the various claims management companies, law firms. And as I've said, there were already a vast number of complaints and county court claims, which ultimately prompted the FCA to step in. It's only really after that where Martin Lewis has become widely involved. So that the main impact of his involvement really is just spreading the awareness to a wider audience, to those who were not previously aware that this was going on, and to the public at large. Obviously, Martin Lewis is a public figure. He's got a national TV show. So as a result, the dispute has attracted more press, and with that, more awareness. What we've seen, and really the impact of this, is it's led to lenders and retailers being even more inundated with complaints of this nature and having to spend then more time and resources in investigating and responding. Once the pause on formal responses to regulated complaints has stopped, whether that's in September this year or later, the lenders and retailers will have to actually respond formally to each and every complaint made, which will be a huge task, really, as a result of the awareness that Martin Lewis has brought.
Yeah, because I think it was reported that, was it something like 2 million downloads of the template from his website? And you mentioned there about the September deadline. Do you think there is much flexibility around that?
I think there is. I mean, the FCA have started their investigation in January this year, and they've given themselves 9 months. But they said when they announced it that September deadline is not set in stone, and they will have or may have the ability to extend that deadline. I mean, if you think about it, they've got a lot of information to troll through. If they're looking at the use of DCAs in the automotive industry, I mean, it's worth bearing in mind that DCAs weren't banned until January 2021. So that's a lot of information to go through, because almost all commission arrangements and most the majority of finance agreements were probably DCAs prior to January 2021. So the reality, I think personally, the reality of them making a decision and forming a proper view by the 24th of September is going to be extremely difficult. I think it's likely they'll extend the deadline.
Yeah.
And I mean, obviously, we're talking there of obviously where the FCA are up to, and where are the the financial ombudsman? Are they involved with this? I mean, you say the complexity of it. The period of time. This is pre-Jan 2021, so then you've got data, information, redacted information, who holds the paperwork for some of this stuff, and if it's still available. And then, as we talked about before the show, the complexity that goes into the deals within the retailer's environment, where that's negative equity, over-allowance, cash back, available credit scoring, etc. This must be a mammoth task to actually undertake and get involved with.
Absolutely huge. And I think that's part of the reason why the FCA have stepped in as it has, because the FOS were being tasked with reviewing these complaints, and quite a few of them at that. And I don't think they'd have the resources to go through it all without having some form of framework as to how these types of complaints are supposed to be treated. We talked about before the show began that we don't really have a binding decision from any sort of legal authority as to whether or not there has been any breaches of the consumer credit source book, or if there's been any misconduct in using DCA models. DCA models were not banned at the time they were used. There were legitimate ways of or legitimate agreements between lenders and retailers. And the question comes down to, were they permitted to do so and use them? And was there any harm to the consumers in using them? And with that becomes a myriad of different other questions which need to be considered, such as the individual's personal circumstances. What ranges did the dealers have to offer? Did they start at the top, or actually what I've seen is more common? The majority of transactions were probably actually close to the dealer's bottom range. And then there's the question of the dealers can't actually offer these interest rates. They just get the ability to apply to the lender between that range. And it's the lender's decision then to assess credit scores, credit risks, and whether they're actually prepared to lend at that interest rate based on a variety of factors. And that's out of control of everybody. I mean, let's say, for example, a broker had the ability to offer a credit agreement at 5%. Doesn't necessarily mean that customer's going to get a finance agreement at 5%. They could apply and be rejected, and the lender will say, we won't lend at 5%, but we've reviewed his credit file and scenario and we'll lend at 8%. Well, what's wrong with that is the question, I suppose. So there's lots of minutiae and detail that need to go into reviewing these. And without any real guidance as to the legal position, the FOS are just sort of stabbing in the dark, really.
And Lewis, you're working very closely with dealers at the moment, and you were saying that the amount of administration that they're facing now because of this high profile campaign, it's causing them a lot of extra work. What are the current ramifications for dealers, and what are you actually advising them to do?
So the ramifications, obviously there's the time and resources spent in dealing with these types of complaints, which in themselves are huge, especially with the huge numbers of complaints we're seeing now as a result of the various television campaigns and the press releases. But as well as that, the implications in a financial sense are huge, with each complainant seeking compensation equal to the amount of commission paid by the lender, plus then interest from when that commission was paid. The majority of finance agreements prior to January 2021 were based on DCA models, and they were commonplace across the industry at the time. There's a somewhat technical argument as to when the limitation period of 6 years begins to run, and if you can bring a claim that was a finance agreement entered into 8 years ago, for example. But even if taken 6 years from each transaction from now, that's still a huge number in terms of compensation or the amount of claims. For dealers as well, they need to consider what lenders are going to do. Because if the FCA talking to lenders and making them do something or asking them to do something, are the lenders then going to look to the dealer to pass any liability to them or ask them to share in any compensation, or even just pursue the dealers as a whole? So it really has the potential to have a huge financial impact on dealers and their profitability. But that said, from a purely commercial perspective, we're in a cost of living crisis at the moment. It might be that some lenders or dealers may have a more positive outlook. If compensation's paid out, that money's back in the hands of consumers. Extra money in the hands of consumers is no bad thing, because that may in itself come back into the automotive market and help stimulate it, with those customers got a bit of extra cash looking to swap their car or buy a new or used vehicle. And ultimately, the cycle of life, the money may go out from the dealers or lenders, but it might end up going back in. So it's a question of perspective, and only the dealers and lenders will know, really. But the ramifications from a financial sense, if it's found that these DCAs were unlawful, is huge.
You make it quite clear there, Lewis, that sort of every cloud has a silver lining, which I think listeners to the podcast will really appreciate hearing. And Lewis, what is the likely timeline? We've talked about this 24th of September deadline possibly moving. I'm just wondering what the next practical steps are for dealers who are looking at their exposure to DCA.
Yeah, so the September deadline really is what we're looking and waiting for from the FCA. But there are still some claims management companies that are pursuing these claims through the county courts or are sending letters of claim. So rather than a regulated complaint, these are disputed claims outside of that arena. These still need to be dealt with. So what we're advising dealers to do is to take legal advice as soon as possible, really. We believe that these claims and complaints are entirely defendable. In fact, Geldard and myself have been involved in a number of DCA claims at county court level, and we have successfully defended them. Other dealers and lenders have also been successful. It seems to me that I can't really see how the FCA can determine that there's been any breaches of conc on a broad brush approach. Each case naturally turns on its own facts, of course, and needs a thorough examination of the evidence to determine if there has been a breach, and if so, whether there's been any loss or harm caused. The main thrust of the allegations against dealers is that they were under a duty to provide advice on a disinterested basis, and that the commissions were fully secret, with consumers not being told about them. This is, of course, in breach of CONC, which is alleged to have caused them some form of financial loss. But that's important because redress is only legally available if the commission was fully secret, but also if there was some financial loss that's been suffered as a result. Now, the majority of dealers and lenders will actually inform the customer, typically via their initial disclosure documentation or pre-contract credit information, that commission may be paid for the introduction to the lender. The majority of the complainants argue that the use of the word may there, so may be paid, as opposed to will be paid, is not sufficient in circumstances where the dealers, the brokers, know that commission will actually be paid because of the DCA agreements. But it is established law that if someone is told that something may happen and it does, then what happened cannot be said to be a secret. This is really the crux of the issue and is causing some legal debate in the courts, and there have been mixed decisions, views at a fairly low level within the county court, mostly because of the values for each individual claim. A couple of £1,000, it's all been part of the small claims process at the moment. However, regardless of whether or not there's been a breach, there still has to be some consumer harm in the form of a financial loss. And the real question is, what is that loss? Because the majority of customers are mainly concerned not about commission or interest rates, but if the monthly payments are within their budget for the vehicle that they want to purchase. Most consumers these days are savvy enough to shop around before committing to a purchase and will be aware whether the deal they have is competitive. Retailers will advertise the interest rates that they'll typically offer. And so if that customer's happy with the deal and the monthly payments, then where's the harm in that? There's no guarantee that it'd be accepted for a lower interest rate or that one would be offered to them in the marketplace. Most realise that, having done their own research, which is why they came to that particular dealer in the first place, knowing the deal to be competitive. And these are some of the points that a court will consider to determine if there is actually any loss in that particular case. And it naturally comes down to what was said and done by the particular dealer, the particular lender, or that particular consumer in each single scenario. It's not really something that you can take a broad brush approach to, in my opinion. But our view generally at Geldard's is, we'd actually argue that there's more harm to the consumer now, as the interest rates since January 21 have been fixed, as is the amount of commission. Dealers, as you know, price their vehicles with an element of profit. Some of that income stream comes from finance commission, which is normal and accepted. So if the monthly payment is out of budget, these days there's not really much a dealer can do. Before, using the DCA models, they could have attempted to do something, using their discretion on the interest rates to get the vehicle within the particular customer's budget, the dealer themselves choosing to forego some commission and reducing profit on a particular sale. Now that's no longer possible, and the consumer can either afford the monthly payments, but if they can't, then they've just got to look for a more affordable vehicle.
And I mean, that's before you even consider things like over allowance, negative equity, and things like this that we all know, particularly in the dealer space, that finance commission was used to help customers out of negative equity situations, or if they required some cash back from a vehicle to help pay off something. There's all this that gets involved with that. I mean, it's like I say, it's a very complex space, and you know, they say it's not quite PPI.
The difficulty with PPI was that the commission that was paid in PPI was a very high percentage of the actual product premium, and the product premium was made up of the commission that was actually paid. This isn't the case here. The consumer's not paying the commission. The commission amounts not been added to the price of the vehicle. the commission amount is made up of the profit that the lender makes for lending that sum of money. If they choose to just share some of that profit with the dealer, it doesn't really impact the consumer.
No, that's it. It's a huge difference on this. So I think, for me, I know that the listeners will be absolutely, looking forward to listening to this, the detail and behind all of this. And obviously when you get down to the legalities and the complexity of it and the potential outcomes and, like you say, the potential outlook of a opportunity, I suppose, like you say, if there is any payouts, then it comes back into the sector. But I mean, just want to say, a huge thank you for coming on today, Lewis. It's been insightful for not just probably me and Curtis, but I know definitely insightful for all the listeners to the podcast today, listening to this. And I know that recently there has been a blog on the Geldard's website that Jonathan Butler did, that anybody wants to go over to the Geldard's website, they can see that alongside other content that you do put on your website, and we'll share that link on the LinkedIn group as well from ourselves. And just to finish off, obviously we've got on the 16th of May, previously mentioned on the Saturday Headlines podcast, that the Vehicle Remarketing Association are supporting an event down at Milton Keynes Stadium for retailers and lenders within the sector on the subject of DCA. And we've got the pleasure of two KCs joining and sharing their views from a legality perspective, with Jonathan Kirk, KC, and Jonathan Goulding of Guff Square Chambers, and they're going to share some of the legalities around this in a bit more detail from what you've been sharing there, and hopefully we'll see you there, Lewis, on the day as well.
Absolutely, yeah. It promises to be a really interesting event, and to hear the views of the two KCs. And they go into a lot more detail than what I have in the short space of time I've had here. But it really is an interesting topic, and there's lots of variables and differing views as well. So it'd be interesting.
No, and I know Suzuki will be there, because Suzuki are helping host this with the support of Dale White, who will also be sharing a 5-year view on Suzuki's EV strategy. And I think there'll be a few cars on display. But yeah, we'll share links through the podcast newsletter and on our website of where you can sign up if anybody wants to attend that event. There are still spaces. We are limited to 120 on the day. But there are still some spaces left if you do want to sign up for that. So just remains to say, I mean, huge thank you from myself, and I know, Curtis, you'll probably feel the same. I think we've probably learned more in this 30 minutes around the subject of the DCA than anything else.
Yeah, you're absolutely right, Phil. I mean, we do talk about this on a regular basis, but this has given certainly us and the listeners a greater insight into where we are at the moment and where it's likely to go with DCAs. So many thanks for joining us, Lewis.
No problem at all.
Thank you. So this is a special midweek podcast, and Curtis and I will be back this Saturday with the usual Saturday headlines, with a snippet of this interview with Lewis as well. So it's a goodbye from me.
And it's goodbye from me.
Thank you for listening to this special weekday Motor Trade Radio podcast, powered by eBay Motors Group. Philip and Curtis will be back with the week's big motor retailing headlines on Saturday. Live, on demand, wherever you are, and on your podcast feed. In the meantime, if you'd like to get in touch with Philip and Curtis, come on the show or send a press release, then email them at motortraderadio@yahoo.com. You can also join the Motor Trade Radio, LinkedIn and Facebook groups, or follow the podcast on Twitter. You've been listening to the Motor Trade Radio podcast, bringing you all the chatter that matters.